Hi, this is Deanna Walsh. You probably recognize me from the last time you reviewed the lecture. And before we start lecture 8, which I find very, very interesting, and that's why I want to share with you, remember the big picture, the purpose of business. Society expects business to make society better without harming it. Very important that you keep that in mind. Make society better, make a better life, better quality of life without harming us. And of course, what is the underlying goal of the legal system then is a balance. The word is balance. Balance between the individual right, whether it's an individual, a person, and whether it's a business, because the business becomes an entity under the Constitution, and the rights of society at large. And who's the society at large is the reasonable people. And who are these reasonable people? A group of people that have little disagreement about the same issue. This is very important that you remember through some of the situation, because that's what the court has to decide. And this is very important. And usually the lower court decides from an ethical perspective consequence. The appellate court usually decides from an outcome perspective, and the Supreme Court usually make a decision because of our rights under the Constitution. The higher the court, the more we have to make decisions according to the Constitution. So lecture 8 is going to be of what extent should government act. Here we go again. We have the freedom. Our companies has a freedom to do anything they want to. Most of that, again, is to make profit in an ethical manner, and also to be socially responsible. But then, what should government do to ensure human health and safety on the job? And you're going to see what is safety, and where is this job, especially in our today's society where we are traveling, we're working from home. What's going on here? So the first part is there freedom and fairness in workplace risk-taking. And this is something very important to share, because you know that many times we start working in a company and we are exposed to chemical that we don't know what those chemicals are going to do to us. And therefore, is that freedom? Do I have the freedom to work in a company knowing that there are chemicals that will damage my life, my whole situation, even the next generation? And is it fair to do that? To take risk and then not making the employer liable. That's the thing that makes it very interesting. So we're going to start with state worker compensation, which is an act. That means what? Congress enacted. That means it's for the good of society. That means what's the purpose of this worker compensation? Who's going to earn, or who is this act trying to protect? In the United States government, they regulate all kinds of worksite safety. State worker compensation is almost every state has their own law, their own act. There is not such a thing as a federal law. And it's very, very interesting by that. And this is a chart that I just show you a different kind of court. It's the administrative law court, which is a little bit different from the typical trial court. You have the complaint, the same reason, you have the answer. Then you have a hearing before the administrative law judge. There's no jury. Then you have the order. He decided, instead of being an opinion that becomes case law, you have an order of the administrative law judge. Well, you don't like his decision, then you appeal to the governing board agency, final agency order. Well, you don't like what they decided because maybe they affirm it, maybe they reverse it. Then you go to the appeal court of the review of the agency decision until you go at the end, the court order, the regular court. So this is just for your own to see the procedural and a different situation that happens. Under the State Worker Compensation Act, the right to recovery is determined without regard of the existence of negligence or fault. What I mean is, around 1930, 31, 32, when we had the Industrial Revolution, we had a lot of immigrants that didn't even speak English working in a factory, working in industry. And they would be getting hurt with the machine. Well, it's not nice that a worker sue his an employer. I mean, after all, the employer is the one that gives you a paycheck to get a job done, and that is not nice, or it's not ethical for you to sue the employer. So they decided to have this statute where it provides some kind of insurance, and we call it no-fault insurance. If the employee gets hurt while he's working, then, and it's the employer has insurance to pay for the injuries, and this is where you don't have to prove negligent, you don't have to prove if there's a duty, you don't have to prove that the employer had an intention to hurt you, not just you get injured while you're working and the insurance is there. To be compensable under workers' compensation, the claimant that files the complaint, which is usually the injured employee, must prove that the injury arose out of and in the course of his or her employment. And today we have a lot of problem in the course of employment because most of our jobs are not 9 to 5 anymore. In 1998, there was a report that the International Labor Organization estimated that 1.1 million work-related deaths occurs each year. 1.1, many of which could be prevented. And again, make society better without harming it. Nearly 300,000 deaths are due to exposure to a hazardous substance that lead to cancer, heart and respiratory diseases. And the biggest one is asbestos alone, which causes 100,000 deaths annually. So here's a situation where, you know, we have a right to life, we have a right to property, we have a right to pursue happiness, and we are finding out these statistics, so the government has to do something about it. Who do you think bears the responsibility for the maintenance of a safe working condition in an American-owned firm that is located in a foreign country? And with the global economy, you know that we have many American-owned firms that are located in another country. And if somebody in another country gets hurt, who is responsible? Who is responsible to make sure the employees does not get hurt? Is it the corporate owners or the managers? Because you have the shareholders and you have also the managers that runs the corporation. The foreign government or the American government, an international safety and health organization, or the individual American, who really end up having the responsibility to provide a safe place where you work. And you'll see through this lecture who is really becoming responsible. Since the early 1900s, every state had adopted a statute to pay employees for the work-related injuries. Originally, it started with the industrial because we would have machines to cut wood, to mass productions, and we had a lot of factory workers that did not know even how to read or write, at least not English, and they would get hurt. And if you, even to this day, when you look at the statue, you see that they even tell you the price, you know, how much for an eye, how much for a finger, how much for a leg, and also how much for also to pay for the attorney, which is like, I think, $70. I don't think it's any more than that. And the employer pays the insurance company to do that, and the employee is protected under this insurance. But it was definitely parts that were missing, something in your body, that you were injured in your body because you were working with a machine. The second phase that we had in workers' comp is occupational disease. And that means that while you're working, you're exposed to chemicals. And next thing you know, you might be retired and you're playing golf and you start coughing. And after a while, you go to the doctor and he says you have lung cancer. And you say, lung cancer? I don't even smoke. You know, here I am in Florida. So, well, what were you doing 40 years ago, 20 years ago? Well, I was a chemist, or I was a maintenance person, or I was a mechanic. Were you exposed to chemicals? Yes, I was exposed to chemicals. Well, again, this is injury. So the statute of limitation is 2 years, like a tort. And of course, now, wait a minute, I'm retired already. I finished, it was 5, 6 years ago that I was working, and just now I discovered that I have lung cancer because of, there's a link there with the chemicals that I was working. And what we have, at least in New Jersey, and I'm pretty sure in many states, we have the discovery rule. That means that the statute of limitations start running from the day that you have discovered that you have lung cancer. That can be linked to the occupational diseases, to the work that you were doing because you were exposed to chemicals. And that's very, very interesting. And many times the estate, the person might be dying, and the estate can sue the company because the person died of a lung cancer because it was exposed to chemicals. And of course, the third phase, which I find it very interesting, is post-traumatic stress. And there is an interesting case originally that started this thing, and it was from New York, of all time, in the state of California. And she was a bus driver, students. And while she's driving the bus, she sees an accident. And she stops, you know, everything stops right away. There's an accident, an ambulance, and she walks out of the bus, and she's going to see who is, you know, what can she do to help this situation. And of all the things she sees, the young people of the bus that are now dead, they're neighbors of hers. They're kids of some friends of hers. Well, she's pretty upset, and next thing you know, she cannot drive the bus. And therefore, she files workers' comp because every time she goes into driving the bus, she remembers the scene, and it's very psychological. And of course, she goes to the worker compensation, she files a claim, and of course, like the chart I showed you before, you see the different board. It says, no, it's not work-related. No, it's not, because she was what? She was working on the bus. She was leaving the school. She was dropping off kids at their pickup place. And next thing you know, this is a car accident. The car accident it's nothing to do work relating. The only thing that it could be a little linked to work relating is that she's driving a school bus, which is still in a school bus. So, but she's emotional. She cannot drive the school bus anymore because of this accident. So what was very interesting, it goes through the different board that I showed you before with the chart until it comes to the last board. And of course, no, it's not workers' comp, it's not work-related, it's not injured while she's in course. And of course, by the time it goes to the Supreme Court, the Supreme Court, was the injury accidental? Well, for her to be so upset, psychological, it was accidental. There's no question that she saw something that caused her not to be able to drive the bus anymore. And then the next thing, did this injury arise out or in the course of employment? Well, in the course of employment, we have something, because she was still working in the bus company and driving, and that was her employment, driving the bus. So this injury occurred while she was driving the bus, and therefore the Supreme Court said, yes, she's entitled to workers' comp. It is worker injury related. Therefore, this is the third phase. And I think that today, many times, and we did have some cases where people, because of merge, they were downsized, and then they were looking for a job, and it took some time, you know, over a year, sometime 2 years before they find a job. And there have been cases where unemployment ended. So they would file workers' comp, because the logic behind is you're having a hard time finding a job because you're depressed, because you were downsized and you have bills to pay and maybe even college and kids. So could it possibly be that you cannot find a job because it's linked to the downsizing of the company? And that would be the situation where workers' comp would cover these people until they find a job. So that's very interesting in that way. One interesting case that I'd like to share with you, that it's also a workers' comp law in New Jersey. This was a Michigan case. And this guy got sought workers' compensation benefit for chronic alcoholism, asserting that the condition arose out of his employment with a brewery and resulted in his disability. To give you a little background here, this guy was rehabilitated. He was an alcoholic person. He was rehabilitated. And guess what? He goes and finds a job at the brewery. And there is such a thing in workers' comp that if you have some kind of condition, back pains or anything that and then you're going to work for a company, and whatever you're doing is aggravating the precondition injury, the company that employment aggravated will have to cover workers' comp. So here is a situation, and you have to remember now, he's rehabilitated. He goes to work in a brewery. The brewery can ask the question like, oh, by the way, are you a rehabilitated alcoholic? That's discrimination, disability, forget it. You cannot do that. So they hire him. If anything, he should not have gone to work in a brewery if he had a weak spot about alcoholism. But let's see what the case and how the court decided this case. So the Worker Compensation Appeal Board awarded benefit and the employer appeal. So according to the board, they say, yeah, he's entitled to benefit because in the course of employment, working at the brewery, his alcoholism got aggravated, therefore it's a workers' comp recovery. The issue, can ordinary diseases of life be compensable as an occupational injury or disease under a Worker Compensation Act? Yes, the court says. Clearly had a disease of alcoholism, and whether this disease was an occupational or just an ordinary disease, it's irrelevant. If you have a disease, it's irrelevant. But if in the course of the employment, your disease, any disease, was aggravated by your employment, then you can file under workers' comp. Alcoholism, the judge says, like cardiovascular disease, is an ordinary disease of life. And the allegation is that the course of the disease was contributed or aggravated by the employment. Based on an ethical perspective then, from your viewpoint, do you believe that Chockey disability should be compensable, industrial accident, or occupational disease? This is what I want to hear from you. What do you think about this situation? Because, you know, from a business perspective, this is very expensive. When I was working for the corporation, every month, every quarterly, as a matter of fact, we would get from the insurance company, workers' comp, you know, how many people got hurt at the company. And if that increased, our premium increased. And they would say, watch out, because this quarter, more people got hurt. You better comply with the law and make sure your employees, otherwise your premium will go up, and it's very expensive. So here is a situation where somebody has a disease, and if the employment at the company is aggravating the disease, the company will be liable. From an ethical perspective, what do you think? What do you think we should do? So please post your argument or your view on the bulletin board. Thank you.